questions. Fantastic. Looks like that recording has started. So Charlotte, wonderful. You can click over. Thank you so much to everyone who's joining us here today for the next in our series of Intro to webinars that we've been doing for a number of months now. In the Pipeline Industries Guild. So if you've missed any of the previous ones, lots of them are up on our YouTube channel, Introduction to Water Treatment, and a few others that we did earlier in lockdown. And the Intro to series was just an idea to give an overview to people who might have vague areas of knowledge of different aspects of the industry, but want a bit more in-depth and talking through things that are potentially new to them or that they've heard through. So they've been a really popular series of webinars, and we're hoping to continue them with lots of different themes and topics. So if you've got any requests or you've got any topics you could talk on, please do let us know. This one is being hosted by the Wales and West branch. Our webinar slides seem to have disappeared, so I'll continue talking and hopefully they'll appear. We've got Molly and Charlotte from Fisher German, who hopefully reappear any second, are going to be giving us an intro to laying pipelines on private land. Molly is an associate at Fisher German and Charlotte is a surveyor. My talking is getting increasingly slow in the hope that the slides will reappear.
Is that back, Laura?
It's not back for me.
Sorry, everyone. Bear with.
I think Kate and Catherine, we've agreed I probably should never now host these things because despite the fact I can't touch them, I seem to have an amazing ability to curse webinars. So let's hope that it comes back up. Is it just now? Is it just okay? Right. In which case, let's not worry about the fact that I can't see it. So Molly and Charlotte give us an overview, introduction to laying pipelines on private land. I'll let them introduce themselves in more detail. But what we will ask is if you could pop your questions throughout the session in the chat. I can definitely see the chat, so that's a positive. And at the end of the webinar, I will then ask Charlotte and Molly, pose the questions to them. If we don't get through all of them in the time, then we will ask to answer them and circulate them. So I will hand over to Charlotte and Molly, who are clearly more able to see tech than me. Thank you very much for attending, and Charlotte and Molly, over to you guys.
Thanks, Laura. Hopefully everyone can now see the slides. Do just shout if there are any technical issues. So good afternoon and welcome to this webinar, which myself and Charlotte from Fisher German are going to be presenting. This presentation, as Laura touched on, is aimed at giving a brief overview of the different legislation gas and water companies can rely upon when installing and maintaining apparatus. And also the key challenges that we face as professional advisors in relation to pipe laying within private land. So just to provide a bit more of an introduction to myself, as Laura said, I'm an associate based in our Worcester office. I joined Fisher German in 2016 on their graduate programme, and in 2018 I became a qualified chartered surveyor. In 2019, I became a fellow of the Central Association of Agricultural Valuers, and I work across a range of the different sectors. However, my main focus is in the water industry.
Hi, I'm Charlotte Jones. I joined Fisher German in September 2020 as a graduate. I previously completed a placement year as part of my university degree with Fisher German in 2018-19. I qualified and passed my APC in November 2021. I'm currently based in the Worcester Utility and infrastructure team. I'm involved with a large number of projects across the sectors, but specialise in the gas projects as well as ongoing management and maintenance of oil pipelines. So just a brief introduction to Fisher German. So we are a national multidisciplinary service provider. Our utilities and infrastructure sector provides advice to multiple clients across the industry, including the water and gas sectors. Our utilities and infrastructure team spans across the UK, providing consultancy services nationwide. We're split into 6 main regions, which allows us to be based suitably for projects located all over the UK. Our most recent office is located in the east in Bury St Edmunds and is due to open this summer.
Okay, so just moving on to the pipeline sectors that we work in. So we work across a number of different sectors, including water, oil and gas. Shown on the screen there are a number of our clients that we work with. As you can see, we work with a range of different companies, some regional, some multinational, operating across the world. All our clients work under different legislations which govern what they can and can't do, which we're going to touch on in a bit more detail later on in the presentation. Some sectors have more powers in terms of being able to access private land compared to others, and we'll explore the key differences as we move through this presentation. Just to note as well, we do also work for wind farm and power clients. However, we haven't focused on these within this presentation.
So just a little bit about our purpose and what we do and how we add value to different projects. So we provide advice and assist with acquiring land rights for water and gas schemes. This may be by negotiation or serving a notice of entry. We review different projects and explore the feasibility and review options for routing of apparatus prior to schemes commencing. We arrange access to sites with owners and occupiers. We are a key point of contact for many different stakeholders, and it's vital that all these parties are kept informed at every stage of a scheme or project. We agree and advise on mitigation and accommodation works, and advise when programme changes may be needed due to a difficult landowner, or when assessing ground and weather conditions where compensation may be inflated if access is taken. We assist with discussions and review compensation claims submitted after works are completed, and advise the client on likely exposure prior to a scheme commencing, and the reasonableness of claims submitted by external professionals. We are also involved in future maintenance projects of existing apparatus and manage sections of apparatus for a number of different clients.
So as Charlotte touched on in the last slide, our work is focused massively on stakeholder management, which is vital in the delivery of any pipeline project to ensure that all parties have a satisfied outcome. It is also vital to build relationships with all of these parties in order to complete any future work that may be required on any of our clients' apparatus. It is very easy to be quite short-sighted with projects and just work to completing the project in hand, say to install a new section of pipeline. However, we often advise on the future impact of not maintaining relationships with landowners and occupiers, and the implications of gaining entry in the future for any repair work or required maintenance if these relationships are not carefully considered. Ensuring a good relationship is maintained is therefore vital, and a responsibility of all parties working on a pipeline project to ensure that we're all working together for the desired outcome. As you'll see on the screen there, we liaise with a large number of stakeholders to ensure a project is successfully delivered. One of our key stakeholders is the owner-occupier of the land, and working with them to ensure disturbance to them is kept to a minimum. Once a project has been received from a client, steps are taken to engage with a private landowner or occupier to explain the works to them, whilst also considering the client's deadlines and timings. We also work closely with other people involved in a pipeline project, such as ecologists, planners, where planning may be required, contractors, designers, and other third parties, such as local authorities, which can often take longer to deal and liaise with, so early engagement with these parties is key. Landowners and occupiers often appoint a third-party agent to act on their behalf, so we are therefore frequently liaising with other agents, as well as just owners and occupiers. And finally on the screen, our client, be it the water or gas company or other who we are representing, who we will keep updated throughout the whole scheme, particularly of any stakeholder difficulties which may lead to increased cost exposures or time delays to the schemes as we go throughout the project. Just to note on this slide as well, we do often come across unregistered land parcels and have to work to identify the landowner. It's therefore vital to engage early during the consultation period to ensure we have implemented an effective stakeholder management plan as to how we will deal with these land parcels, so that we can provide the client with advice of the next steps moving forward.
So now I'm going to touch on the main legislation that water and gas companies can rely on when delivering pipeline projects. So firstly, the Gas Act 1986 gives rights to public gas transporters who are licensed by the Director General of Gas Supply to convey gas through pipes to premises or to a pipeline system. The gas transporters are regulated by Ofgem. Gas transporters' duties are to develop and maintain an efficient and economical pipeline system for the conveyance of gas and to connect premises to the gas supply system. So we're just going to touch on the different agreements used when delivering a project. So firstly, easements. An easement is used to secure much of the gas apparatus being installed. This is registered with the land registry title and sits with the land as opposed to the landowner at the time. It is often a permanent easement that grants rights for the gas company to enter the land following the initial installation of the apparatus to inspect, maintain, alter, renew and abandon the apparatus. Following on from easements, some of our clients utilise a consent to lay, which effectively acts as a licence to agreement for an easement and allows works to commence on site prior to a legal easement being completed. This is often used when a scheme is time pressured. It is not used by all of our clients. There is a risk that a deed of easement won't be entered into by the grantor after signing the consent to lay. So it's vital that it's used only when time pressured and the risks are known by our clients. Following on from this, option agreements can be utilised as well by gas companies to secure apparatus ahead of entering into a formal deed of easement. Leasing land, gas governor housing sites are often held under a Landlord and Tenant Act lease. Commercial tenancy, it is important to note that during the lease negotiations, we ensure that the gas transporter is contracted into sections 24 to 28 of the Landlord and Tenant Act, which affords them with security of tenure provisions and allows lease renewals to take place once the apparatus is installed for the initial period. Temporary licence agreements are often used for compound areas during the construction phase of a project, and similarly leases can be used as well for compound areas, perhaps where they're required for a little bit longer. A statutory licence is used for services to individual properties and is signed by the landowner. And then compulsory purchase, the Act does provide gas transporters with the right to acquire land or rights or to create new rights in land. And then finally, prescriptive rights. These are often explored by gas transporters for pipes without documented rights or where a formal easement cannot be located, where they can establish long use for 20 years or more. And rely on those to take powers of entry. This is normally a last resort when a formal easement cannot be located, however. So if a public gas transporter wishes to enter land to lay new pipes without using CPO, it has to solely rely on negotiation. There is no equivalent of a 3-month notice of entry used by water companies. So Part 1, Schedule 3 of the Act grants a gas transporter the rights to acquire land and rights. However, they will always seek to put in place a voluntary agreement, even if CPO is running in the background for a scheme due to the scale and size of the project being delivered. Whilst gas transporters have the rights to compulsory acquire land and rights, it is a very costly, time-consuming process. It is always preferable to use negotiation where possible to maintain relationships with the landowner and occupier. So powers to place pipes in or under streets are included in Schedule 4 of the Gas Act. The definition of a street can be found in Section 48 of the New Road Streetworks Act 1991. This is often dealt with by the gas transporter and the design and field contractor, who would deal with private streets and the local authority to arrange those works. However, it is worth engaging with ourselves early to ensure a highway search is submitted to clearly define whether or not an easement needs to be negotiated and put in place. This often reduces both time and cost to a project.
So now moving on to the Water Industry Act 1991, which is quite different to how the gas industry operates. So just touching on the land rights utilised by water companies. The Water Industry Act is arguably one of the most powerful of the statutes which our clients are able to rely upon to deliver pipeline works. The key aspect to consider here is the use of serving statutory notices, which is used for the majority of pipeline projects that we come across. We do also use temporary licence agreements, similarly to what Charlotte touched on for things such as compound areas that may extend out of our working area. Also easements. There are also some instances where a statutory notice may not be applicable and may not be able to be served. We would then look to formalise the rights by way of an easement with the landowner. This is used less frequently, but we do sort of see it from time to time. So it is something I will just mention in a bit more detail later on. So as I said, the key sort of way to deliver a pipeline project for water is by the service of statutory notices. The Water Industry Act contains provisions which empower water companies to lay and replace pipes and also to carry out works on existing pipes in private land. These provisions include statutory periods of notice, which must be given in full to owners and occupiers before any work is undertaken. The key legislation to look at here is Section 159 of the Act. This gives powers to lay a relevant pipe, whether above or below the surface in private land, and also to inspect, maintain, adjust, repair or alter existing pipes. As mentioned, these works must relate to a relevant pipe in order for the statute to apply. The definition of a relevant pipe is defined in Section 158 of the Act. Whether it's a relevant pipe or not depends on the type of pipe and also the nature of the proposed works. So it is important to consult with us early to check if a notice, if it is a relevant pipe and therefore if a notice can be served. This can include things such as a water main, including a trunk main, resource main, a discharge pipe, or any sewer or disposal main. The statutory notice periods, which I mentioned and must be given, is 3 months for laying a new relevant pipe, or 42 days for altering an existing pipe. This includes changing pipe size, changing its course, moving it, removing it, replacing it with a pipe of the same description, but it must be within the same land ownership. One thing to look out for here is a replacement main may be taking place, but the routing of it may be significantly different to the existing, and it may cross new land ownerships. This would therefore technically be treated as a new pipe under the legislation, and a 3-month notice should be served in this instance. The other key sections of the Act are Section 168 and 169, which give powers of entry for surveys and tests following the service of a 7-day notice. This is often used during the feasibility and design stages of a project to undertake things such as boreholes, trial pits, topographical surveys, etc. If an owner or occupier refuses access to the land following service of a valid statutory notice, be it a construction or a site investigation notice, the water company is able to apply to a magistrate's court for a warrant of entry. Just one key thing to also look out for under the Act is under Schedule 13, some organisations are offered a greater degree of protection from these powers of entry. These organisations are known as protected undertakers, companies such as Network Rail, other utility operators, canal and river trusts, etc. In addition to serving a notice on these parties, they must also provide their consent. While they cannot unreasonably withheld consent, it can take longer to consult with them, and it is therefore worth considering if a pipeline project intersects with any of these parties early on. They may also have other specific agreements which may be required in addition to the notice served. Again, these can take quite significant periods of time to get agreement with them. So please do consult early if a project is likely to impact a protected undertaker. I briefly mentioned earlier on that easements are sometimes used. So just to provide a brief example of this and something to look out for in any of your projects. A water company does have power to install a discharge pipe under notice. However, they do not have statutory powers to actually discharge into the watercourse. This element would require negotiating an easement or obtaining consent from the owners of the watercourse. Again, this can take time, so if this is something that you're experiencing on one of your schemes, please do allow enough time for this to be put in place. Another key element of the Water Industry Act is the Code of Practice. This is a requirement for all water companies to have a Code of Practice under the Act. Essentially, the Code of Practice sets out good practice with regard to water authorities' powers and duties when laying pipes on private land. It explains what the landowner can expect and when water companies enter their land to carry out the proposed works. It is therefore essential that it is adhered to because it is in the statute, it's there in the legislation, but also because there can be financial penalties awarded to the affected party if a breach occurs. So it's therefore crucial that water companies are following this code of practice. Breaches of the code include poor consultation regarding siting of above ground apparatus, excessive disturbance, or poor reinstatement. So just for a bit of light-hearted overview of the importances of code of practice and practical considerations, Fisher German have produced a video setting this out more clearly.
Meet Tom. Tom is a conscientious site foreman working on a water pipeline scheme crossing private land. Learning from experience, he believes in preparation, planning and best practice to get the job done properly and on time. This is Dick. He is working on another section of the same pipeline. Dick hasn't worked much in private land, but has never had any issues and laid lots of pipes in the highway. How hard can it be? He wants to get stuck in and lay the pipe as quickly as possible to beat the project deadline. And here's Harriet. She owns some of the land affected by the pipeline. She grows crops on the land and grazes cattle. Whilst she understands the need for the pipe and is willing to cooperate, Harriet would be happier if it wasn't happening at all. So, after checking he has the up-to-date engineering plans, Tom starts by checking that all the necessary land entry preparation has been done. He speaks to the surveyor to check that the necessary legal rights are in place for the works and a photographic record of condition of the land has been prepared. He also obtains details of the agreement reached with the landowners about temporary fencing, crossing points and other accommodation works in accordance with good practice. Discussions with the landowners have revealed the presence of underground services and land drainage systems, which were previously not known about. So Tom is fully aware of the need to identify these constraints before starting work. He also checks that a soil, drainage and groundwater management plan is in place and that third-party assets and utilities have been searched for the route of the pipeline. Meanwhile, Dick is pressing on with the construction work. Harriet had spoken to the fencing contractor and raised concerns that the fences were not as agreed in the pre-start meetings, but somehow this message did not get back to Dick. So he starts stripping the topsoil to a depth of 300 millimetres, as he had done on other jobs. Had he consulted with the soil management plan, he would have realised that the topsoil in this particular field was 500 millimetres deep. Anyway, progress is good. Dick is laying pipes before Tom has even finished the fencing. Tom has arranged the fencing to be carried out strictly in accordance with the accommodation works drawings and marked the locations of the land drains and services identified by Harriet. He checks the topsoil depth to confirm the details set out in the soil management plan and starts the topsoil stripping. Tom arranges to divert a 6-inch mainland drain before pipeline commences, as he knows it carries a lot of water and will flood the working area and surrounding farmland if it is damaged. He also checks that the surveyor has discussed the position of the surface-mounted equipment with Harriet and agreed how they will be positioned. This avoids misunderstandings and delays later on and is a requirement of the Code of Practice. Tom can now progress quickly and safely with the pipelaying work in the knowledge that all known constraints have been dealt with. Dick is having a few problems. A land drain is broken, which has flooded the working area and part of the adjoining field, and it starts raining. The working area rapidly becomes very wet, and the unstripped topsoil, subsoil and water gets rutted and mixed up into a slurry. Dick decides to keep working and widens the working area by removing part of the temporary fence. He narrowly avoids severing a mains underground electricity cable in the process, which was outside the area of search for the official route. The site manager has to stop work while the near miss is dealt with, and Dick is disciplined for not checking for the presence of utilities and trespassing. Harriet has been away for a few days and comes back to mayhem. The field is flooded and cattle have escaped onto the working area. She is very frustrated with Dick, as she spent time prior to the works discussing and agreeing the fencing specification, and she told them where the drains were, but no one listened. Worse still, large quantities of her topsoil has been contaminated with subsoil and the soil structure damaged by vehicles trucking through it in waterlogged conditions. All of this was avoidable, and Harriet cannot believe how it has been allowed to happen. She complains to Dick's employers and to the utility company, who take these problems very seriously. Tom comes across unexpected problems on his section too. He finds a number of land drains that were not known about. He marks them on the ground, maps them with GPS, and invites Harriet to inspect the repairs before backfilling. This means there should be no legacy problems with drainage, and even if there are, records will exist of what was done during construction. It is late summer and conditions are ideal for reinstating. Tom arranges for the working area to be subsoiled with an agricultural winged subsoiler before pulling back the topsoil. This removes the compaction arising from the construction traffic and helps the land to drain.
So I've given them all the details.
The project. She is really worried about the long-term damage caused by the flooding, compaction and mixing of the soils, and her pedigree cows got in with next door's bull when the fencing was removed. What seemed like a straightforward matter has become a real headache, and Harriet makes a mental note not to be so helpful next time a utility company approaches her about putting apparatus in her land. Dick is still battling on. He soon realises that the lack of preparation at the beginning is now costing the project dearly in time and money, as well as having to deal with a very upset and increasingly frustrated Harriet. He eventually completes the pipelaying, and as it is now November, he has no option but to continue with reinstatement. This is not easy. The site is waterlogged, uneven and difficult to travel on. A lot of excess concrete and other materials have sunk into the soil where the holes were filled to enable construction vehicles to travel. Most of this is now impossible to see, and Dick decides to level the topsoil over the area regardless, in the hope that it will dry out over the winter and recover. Harriet has seen what has been going on and again complains about the way work has been undertaken. She wants all of the affected areas to be stripped, taken away and replaced with fresh topsoil. But it is unlikely that any equivalent soil can be found in such large quantities, and even if it could, the costs would be very high. So, while Tom is collecting his bonus and moving on to the next job, Dick is still faced with a lot of problems that could take years to resolve, and a dispute with Harriet, who at the outset was keen to help. So don't be like Dick. Do your preparation and make your pipeline project run smoothly by following Tom's example.
So following on from the video, you will note there are a number of factors which need to be identified on site prior to works commencing. A major part of the work is the interaction with landowners and occupiers and carrying out the consultation required to arrive at a preferred solution for all parties. Discussions will include timing of the work. So when installing pipes in farmland, it's vital to consider agricultural operations and, where possible, work around farming practices. This can significantly reduce compensation liability. Construction work is best carried out in the drier months, as soils are less susceptible to damage and construction is more straightforward. We understand this is not always possible due to programming constraints, but having this conversation with the landowner early can maintain the working relationship. Compensation, so we assess the likely losses and advise our client on ways they can be avoided or mitigated. Where losses are not avoidable, compensation is paid to the owner or occupier of the land, and this should be discussed early on. Discussion should also make clear the duty of claimants, so the owner or occupier, that they need to mitigate their loss. Access, so how is entry going to be taken to the land? Is there a preferred route, a more straightforward route that the landowner or occupier would advise? Are passing points required within the temporary fencing being installed, and have water troughs and other livestock equipment been factored into those works to ensure full use of the area outside of the working area? Is there a lock on the gate that needs to be changed for the duration of the works to maintain site security? Where contractors are taking access through a farmyard area, then biosecurity measures may also need to be implemented. As part of this, professional advisors can be instructed on behalf of an owner or occupier. If the claimant decides to appoint a professional advisor, then fees need to be agreed with this person. Both gas and water companies often use a scale to calculate fees and assess the level payable. Record of condition is vitally important to assess what the land was like before entry is taken by any of our clients. This is useful in assessing the loss at the end of the works, and should be undertaken by ourselves prior to work commencing. It must also include accesses as well as the affected area and any areas where access is being taken. It's also important to note that buildings in close proximity to the construction works may also require a building condition survey, which needs to be undertaken by a building surveyor. The proposed location and design of the works should be discussed, and any apparatus being installed once above ground. So for pipes, the good practice dictates that, where possible, marker posts should be left to mark the position of the pipeline. This is important that the location is discussed. Often it makes sense to put them along field boundaries flush with the fence or hedge to avoid damage to the marker post and any damage to machinery that may be driving over the field. Where possible, chambers should be located close to field edges to reduce the impact on farming operations. A chamber located in the middle of a field makes it much more difficult to navigate around with farm machinery as opposed to being at the edge. Likely locations should be discussed and agreed with owners and occupiers in advance of construction to ensure that these permanent features are in suitable locations to for when the land is returned back to the owner or occupier. Land drains, where records of existing land drains are available, these should be obtained from the owner or occupier. As you saw in the video, maps are not always available. However, consideration of land drains should be factored into the construction works, and when discovered, it is important to notify the owner or occupier. Other services searches need to be completed prior to entry to avoid damage to third-party apparatus and agree any crossings if that's required. We utilise line search before you dig to conduct searches of our working areas and engage with the affected third parties prior to the construction phase of a project.
So just a couple of key points to take away from today. We've banged on about it quite a lot, but engaging land and planning consultants early on in a scheme is vital. We can be involved from the outset to assist with routing, advice, etc., to minimise any costs exposure, and we can also help advise on timescales so that a programme can be reviewed collaboratively. It also allows early engagement with landowners, which, as we've mentioned throughout this, in maintaining a good relationship with them is key. So the earlier we can consult with them on a project, the better. Another thing to look out for is any ecology constraints in relation to your scheme, including hedgerow removal, some of which may require consents, which can incur time and costs. Also any other surveys which may be required, particularly from an ecology point of view. One example, a great crested newt surveys, they seem to be cropping up quite a lot lately, whereby we need access to a much wider area of land than just the routing of the pipeline. This is often sort of forgotten about until quite late in the day. So looking at, all your ecology and survey requirements early on in the process is really important. We can then make sure that we have land referenced and consulted with everyone who we need to as part of the project. Also just worth checking the designation of the land. This is something that we can also do to check whether it's a registered common land or a triple SI or perhaps a scheduled ancient monument nearby. All of these come with their own sort of consents that need to be submitted if we are impacting any of these. Again, these are costly and quite timely as well. So it is just a case of making sure we are consulted early so that we can advise you on the steps needed if we are impacting these, or looking at potential routing options to avoid these if we can. Also any planning requirements, we have got a planning team within Fisher German who we work collaboratively with on all of these types of projects to ensure that any planning requirements are met. Most below ground pipeline schemes will be covered under permitted development rights, but it is worth engaging with our planning department early on, particularly for a larger scheme which may require an EIA screening, or for any above ground apparatus which may exceed the permitted development regulations. Also something which is sort of we're seeing more and more now is a biodiversity net gain requirements. From a land perspective, we are often seeing that more land may be required to deliver this element than previously the land that may have been required for a scheme. So again, it is just worth looking at this. Our planners are able to provide more advice on this and the best way forward. And finally, on here, the UK agriculture, which is under unprecedented change with climate change, global markets, the war in Ukraine, and UK agricultural reforms post-Brexit, creating quite a lot of uncertainty for farmers. So it is therefore important that we are consulting with them early and providing, as much certainty as we can in relation to our scheme. It may also impact the compensation estimates that we have maybe submitted for projects in the past. These may now be significantly changed based on the current market and the current situation. As we've touched on, we do reimburse any reasonable financial losses which a landowner suffers, and with these volatile markets it is important to discuss these with us because, as I said, it may well impact the amount that we are paying to a landowner. And just finally, to reiterate again about proactive engagement, clear communication between all stakeholders to ensure that we can assist with delivering efficient and effective pipeline schemes. Thank you very much.
Fantastic. Thank you, Molly and Charlotte, for such a comprehensive presentation. I know every time I sort of thought, oh, a question to note down to ask them, almost in the next sentence you would ask it and I would go, you've answered that, so fantastic. So I'll just give people a couple of minutes to type any questions they might have into the chat box. So whilst you're doing that, I will ask one of my own just to give you some time, and then we'll go through and see what's there. So really interesting presentation. I was wondering, just on your personal experiences, is there anything either when you joined the industry and started training, or indeed now, that's come up that really surprises you about this area and you sort of hadn't expected it? Very difficult one, but I just thought it was interesting to get your views on it. I should have warned you beforehand, but I was musing on it as we were talking, or you were talking.
Right, it's fine. I think more recently, it's just the amount of schemes, etc., that are coming forward, and just the pure volume of work that as an industry we are all seeing, and I think it's it becoming increasingly important are the services that we can offer, just to ensure that landowners are seeing schemes more and more often impacting their land, particularly the bigger landowners, and it's therefore important that we are all working together to ensure that the relationships with them are maintained, because it might not be us that needs to go back in the future, but it might be a different sector that may be looking to install a different pipeline, and we don't want everyone in the industry to be having issues with which can be easily resolved. I think that's quite key, is the volume of work has massively increased sort of recently. Really, that's something I've noticed.
Interesting. I definitely think but it seems to be just increasing every day almost, it feels. So interesting that you're seeing that as well. Great. Well, what I'll do is I'll pop into the questions now. So the first one that came through was from Mike. So do the same regulations apply to other land entry, for instance, connecting solar or hydroelectric projects on the power grid? Now, I know you guys said you were specifically focusing on sort of gas and water. So I guess at a high level, are they quite different? What have you got any sort of quick comments on maybe on that area?
To be honest, it's not a sector that I'm massive, or Charlotte is sort of massively involved in, but it's certainly a question that we can take away, because there are, people within Fisher German who can provide advice on that, and I can get an answer back to you. So Laura, if you're able to ping that question across, I will. I'll get a response. Great, lovely, thank you. Bit of a cop-out answer, sorry.
That is an honest answer, and honest answers are always sensible. And then a question for Charlotte from Martin. You mentioned the discovery of a gas pipeline with no record of an easement being in place. What would you expect the operation to do in such a case? And would any recognition of grandfather rights be appropriate?
So we'd obviously take it back to the client to see how they wanted to proceed. That's when we sort of look at the prescriptive rights and how long the pipe's been there, whether we've been taking entry to it, and sort of if we can obtain as much information on the pipeline as possible. We do the searches, and I know sort of our clients will also do an internal search to locate any documents that might relate to that asset. So yeah, that's what we normally a bit of a last resort, but what we can fall back on, and ultimately we take all this information back to the client to advise on how we can move forward with that.
Great, thank you. Hopefully, Martin, that answers some of your questions. And then Amjad, working area under statutory notice versus compound area, and private license agreement in the water industry. What is your opinion on what differentiates these?
Yeah, this is quite an interesting question, actually, and something we do see quite a lot. Essentially, if we are working in a parcel of land and we've allowed our working area within that notice, if we keep equipment, storage of equipment and machinery within that working area while we are working within that land, that would be covered under the notice, provided we are in the areas that we have shown on the notice plan. I think it's more if we move on and say for a pipeline scheme, we're impacting multiple landowners, we've finished in this person's land, we've moved on and we've kept the kit in the first person's land. That is really sort of pushing the statutory powers that we have essentially for compounds. I think definitely for some of the big water pipeline schemes that I've been involved with, quite often we will look to secure a compound sort of in the middle of the scheme, say by way of a license agreement that may be agreed with the landowner. This can sometimes be done by the contractor directly, or we are able to help facilitate that. So it's looking at that, but I mean, in an individual circumstance, definitely speak to us and we can check that working areas are big enough for what we need when we're working in that person's land to try and cover it under notice if we can.
Great, lovely, thank you. I'm assuming, Amjad has ticked on that or thumbs up, so hopefully that answers fantastic. So now the questions have come through. So thank you for such a comprehensive presentation, Molly and Charlotte. Again, that was wonderful. We look forward, if any of you are interested in our further webinars, if you haven't already checked out the PIG website, please do. There are more events coming up all the time. And so we look forward to seeing you in apostrophe works, where they are, at our future webinars. Thank you again to Molly and Charlotte, and we wish you all a good rest of the day and see you at an event in the future. Thanks again, ladies.
Thanks, everyone.
Thank you. Bye.
Thank you.